All right. Well, at a couple minutes past the hour, I think we've given everyone a moment. I'll never forget being in New York City a handful of years ago, and I got to see an incredible production on Broadway. Whoopi Goldberg was acting in this particular production, and somebody came in after intermission. They interrupted Whoopi Goldberg, and she called the person out and told them that they had toilet paper on their shoe, and it was absolutely hilarious. I maybe one of those things you had to be there. But the good news with this Zoom is if you came in late, I can't see you, so I can't let you know you got the toilet paper on your shoe. But it was so I do apologize for that. Couple housekeeping things. My prepared comments, remarks, education here, if you will, is going to take us about 30, maybe 40 minutes. I've left us plenty of room for questions and Q&A. There is a Q&A box you can type in. So be patient with me. So if you put it in, I'm in the middle of a thought. I know I'm going to potentially answer your question as I share what I'm going to share. And I don't get your question right away. No, that might be why. But I'll probably preserve most of those towards the end. So feel free to type in your questions. As a bit of a housekeeping, I can't give specific tax and or legal advice on a recorded seminar. So if you ask a question that's really specific about something in your life or in a scenario that's in your life, I may give a broad arching answer to that question, but I can't get into nuanced details. I'm not an attorney. So I don't even play one on TV. So if you will. So again, thank you everyone for joining. Again, for those who just came in a couple minutes ago, my name is Kyle Sanders. I'm the founder and owner of Legacy Consultants Group here in Indianapolis. I am a financial consultant and have been one for over nearly 20 years, a little over 20 years, which is amazing because I know I only look like I'm 25, but there you are. So let's talk about this. I think one of the questions that I get a lot is, what is the purpose of estate management? Why would you do this? And I'm using the word estate management intentionally in this presentation because part of estate planning involves managing your estate while you're alive. And so estate management is about preserving the assets you've spent an entire lifetime building. It's about protecting your spouse, your children, other heirs, ensuring that your assets are distributed how and when you want them to be. And finally, estate management is about managing the amount of estate taxes, and yes, those still exist, that may be due after your death. We'll talk about that a little bit. There's some fundamental estate management principles that can help you manage your financial and personal affairs during your lifetime, which is key, as well as after your passing. So, as I shared, my name's Kyle Sanders, firm's Legacy Consultants Group. This is just a core functionality of what we do as estate guidance that we provide for our client families. But certainly we provide guidance well beyond that. So if you have questions, you're a guest of ours here today, beyond what we share here, certainly feel comfortable reaching out to us. We'll make sure you know how to do that throughout this event. So here's a really important thing to understand, right? I founded this firm on the concept that each of us are going to leave something behind. There's going to be our values and our valuables. Let me say that again. One of the most important things that we teach people when it comes to estate planning is that it's important to prepare the people who are going to receive what you send them by teaching them the values that helped you build and live the life that you are living, as well as the valuables, all those documents. And so one thing we don't touch in on here today is that value side of it. That's something we do customary for the clients we serve. So we're going to talk about mainly the estate documents, the planning documents, but no, from our perspective, that's just the very beginning. So let's talk about this. So estate management objectives, it's during your lifetime, right? We want to manage our financial and personal affairs. And second, distributing wealth after your death. So there's two pieces here. There's from the legal side of it, it's called inter vivos planning, or while alive from the Latin, and testamentary, or after death. And those two things come into play for many people. Often there's this transition period between when we're living and well enough to manage our own estate and our own resources, our own healthcare decisions, and when we pass. And so it can ensure possessions go to heirs you choose without endless legal wrangling. We'll talk a little bit about those elements. Through effective estate management, you can avoid, the expenses of probate, depending upon what state you're in, that you're joining us from. Those probate costs can vary from state to state. Some states' probate processes are simplified and low cost. Others can be extraordinarily time consuming and expensive. So I think if we think about estate planning kind of in this tiers of how the estate tax works, and then what are some of the critical documents that are necessary, and then we're going to talk a little bit about just a couple different tactics that one can use. So that's going to kind of be the progression that we're going to go through today. So how do estate taxes work? And what are some of the critical documents that I don't generally use the word everyone, but truthfully, everyone should have on file, married, unmarried, with children, with not with children, regardless. There's some documents that if you could take a breath, you should have those executed upon. Let's talk about the estate tax, if we will. So 1797, the first estate tax was passed, and it was passed temporarily, as a result of dealing with the cost of a naval war with France. And then Civil War, Spanish-American Wars, Congress passed an estate tax that was then repealed. So you can see that this was passed, repealed. And then until 1916, the amendment to the Constitution was passed in 1913. So here's a little fact for you all. It was illegal for the federal government to tax U.S. citizens until 1913. And whomever was alive then, all right, so there was a ratification of the U.S. Constitution in 1913 that gave the U.S. government the right to tax its citizens, lay and collect tax on income from whatever source derived. The Revenue Act of 1916 established the estate tax. It's been modified since. So if you know anybody who was alive in 1913, which I think that would probably be a scant amount of people, will you please make sure not to give them extra scoop of barbecue this weekend? They're not my friend, but there you are. So, and then in 2012, this is funny. Only Congress can get away with naming things like this. So in 2012, the American Tax Relief Act made the estate tax permanent part of the tax code. Yes, a tax relief act made the estate tax permanent. And then in 2017, the Tax Cuts and Jobs Act rose the estate tax exemption. So right now, that exemption is massive. So an individual today can pass $12.92 million onto their heirs. It's up from 11.7 million last year, so it indexes with inflation. But 12.92 million to their heirs without taxation. The calculations you're going to see in a minute, in a few slides, reference last year's number, but this year's number is 12.92 million. So good news. I think the vast majority of the people on this probably have less than 12.92 million. However, that number is coming down, and it's coming down in 2026 pretty drastically. And that change is likely going to pull in a handful of you all on this. And there's another tax we'll talk about that grabs almost literally every American. So let's talk about how we calculate this, okay? And this is why this is one of those taxes that is really unliked by those who've accumulated really massive amounts or meaningful amounts of wealth, is that we take that gross value of their estate. In this situation, we chose a value of $12 million. We subtract the exemption, which was 11.7 last year. It's 12.92 this year. And then whatever's left, that residual, we apply a 40% estate tax. That's why it's so, you hear a lot about this. It's extraordinarily punitive to be in excess of this number. And it's why there's a lot of planning down around this. Now, one thing this calculator does not touch on is what's called income in respect of the decedent, or IRD tax. That's a 50-cent word if I ever heard one. What is IRD tax? Well, IRD tax is a taxation that's applied to any asset that you yourself would have paid ordinary income tax on if you consumed it during your lifetime. You might be saying, well, Kyle, what in the blue blazes is an asset that I would have paid ordinary income tax on during my lifetime? Well, that's your 401k plan. That's your IRAs. So any asset that you have put money into on a pre-tax basis is treated and subjected to IRD tax when it goes to anybody other than your spouse. So in your 401k plan, you have employer match money that's subject to IRD tax to non-spousal beneficiaries and non-minors and disabled individuals. Sorry for being so technical there, but let's just call it non-spouses for simplicity purposes from this point forward. So that's subjected to IRD tax, as well as any pre-tax contributions you've made into a 401k plan. And due to the Secure Act passed in 2019, the first round of the Secure Act, now that taxation is accelerated for non-spousal heirs. So even if you don't have a massive estate, I would say $12 million is pretty massive. You may feel differently. Where I grew up, Miami East High School, 86 graduates, a farm in the middle of Ohio, we'd call that a lot of money. If I found $12 million in a pair of jeans, that'd be a good day. So I guess it's all relative, right? So even if you don't have an estate tax issue, there may be some tax planning elements that is critical for somebody who has an objective of leaving as much of an estate to those that they love as possible. So let's talk about some of the critical documents, okay? There are a number of critical documents you need to have as part of your estate plan. The first of these is the most basic. It's called a will. And a will tells the world exactly where your assets are distributed when you die. And in my opinion, everyone should have a will. But the reality is that over a third of Americans run around without one. And I don't mean to be direct here, but that can be pretty short-sighted. And not just because somebody's wealthy. Because if an individual dies what's called intestate or without a will, it's up to the state guidelines on how their assets will be distributed. And even if you have a trust or you still need a will to take care of the holdings that you might have forgotten to get inside of a trust. Let me talk to you specifically about Indiana, because I think a lot of folks are joining me from the state of Indiana. That's where we're housed, but we know we have some guests outside the state of Indiana, and so this would not be applying to you if you're outside of Indiana. Indiana, if you die what's called intestate, it's a fancy word for saying dying without a will, then you die what's called intestate succession is what applies, which is a fancy way of saying is what does the state say is going to be done with your money? And what is a kind of a mind-boggling thing is if you are married without children, 1/4 of your estate cheats or goes back to your parents. Now, I don't know what your Thanksgiving likes or like your in-laws, but if I know this much, if I didn't have a will, when my wife and I were married without children, and 1/4 of my stuff went back to my mom and dad, that would have been an uncomfortable Thanksgiving if I would have died during that window. So it's such a critical thing in Indiana specifically, for an individual married couple specifically, certainly, and individuals not married to have a will. And because the intestate laws in Indiana are, well, I'd call that a little weird. You call it what you want to. So let's talk about the will and what it does. So this uses the word executor. There's an executor and executrix. The words are gendered on traditional gender terminology. And you name an executor or executrix to oversee the process of distributing your estate. Generally speaking, this executor can take a fee for doing so by tracking their hours, but it's relatively an unpaid thing. Often people think this is giving somebody something special. It's not. I will encourage people to name somebody who's most competent in your family to do so. It can name a guardian, so a will can name the guardian of your minor children, can direct how your property is to be distributed. So I've got 4 kids, and one of the things that our will does is it names kind of what I call the first and second fiddle, right? So who's going to play first if my wife and I are no longer here to take care of our kids? By the way, when you have 4 children, you ask permission to name somebody in that seat. And then we have a backup position, right? Because if that individual is unable to or unwilling to or what have you, or God forbid that person would predecease me, and I don't have the time, or would deceased, we would be in a mutual catastrophe, I want to make sure that we've chosen that person. Why is that so critical? Well, because in absence of you choosing whom, then the courts in Indiana choose, and kids can find themselves in limbo. And so this would be the second, to me, the second most important, but not less important, but just the next one on the list of why an individual should have a will is if you have children, it is a critical element to name who or whom, or the whoms, if you will, of who's going to be stepping into that role. Um, but there are shortcomings. So wills can be contested. They're more easily contested than trust. They do go through probate, which, depending upon your state of domicile, the state you live in, I'm going to use some legal terminology throughout this, just for the purpose of teaching, and then I'll explain the word that I'm using. By the way, I'll continue to do that in hopes that that helps everyone learn a couple legal vocabulary words today. So, and if someone wants to contest it, there is a potential for a lengthy battle in probate court. So they're essential, they're foundational, but they're not exhaustive. And so I think that's critical. And wills are a matter of public record. And so if somebody wants to maintain a certain level of anonymity, a will is a poor way to do that. So probate is a matter of public record. So only a estate management tool you use as a will, then people are going to find out how much you left and to whom. So for individuals with larger estates or a higher desire for privacy, will tend to use other tools in that. So let's dive into some of those other documents, if we will. So healthcare documents. And again, this is where I would suggest that why everyone needs to do some sort of estate management or estate planning is that when we think about all of us, living will, power of attorney, and durable power of attorney for healthcare are three very critical tools that happen. And we're gonna dissect these a little bit deeper and what they do. But the reality is that what those three documents from a high level do is they give the people that you love the right to make decisions upon your behalf when you're unable to make them for yourself. And then we're going to talk a little bit about some financial documents, joint ownership, durable power of attorney. We're going to dive into that a little bit, and then a living trust and how that works. So I don't know how many here, I'm going to date myself in this example, but remember the case of Terry Schiavo. So Miss Schiavo was in a place of full mental incapacitation, often referred to as a vegetative state. And this was back in 2006. And there's been a number of cases that have brought this reality to the forefront. But Ms. Schiavo was severely incapacitated, and her family members battled for years about what should be done. So this poor woman is in a vegetative state in a hospital, and she had no advance directives. She had no living will. And so her wishes, nobody knew. And there was difference of opinion. So in spite of her high profileness, that case was all over the national news. Most Americans still don't have their healthcare documents prepared. They have not had a conversation with loved ones about the level of care they want if they're incapacitated. So a living will, in simple terms, says, I have one of these in myself, right? And it was pretty emotional for my wife and I to go through this process. My wife actually cried and got pretty emotional, which was quite humbling, I must admit. I don't think I'm that great of a husband, but thank you. But the living will simply says this, is that if I find myself in these conditions, this is what you're allowed to do to keep me alive, to sustain life, right? And these are the power you have to, a lot of people say pull the plug is the more simplistic or more street terminology around this, but these documents are much more sophisticated than that. So they get into specifics around food and care and those elements, and it gives somebody the power to make those choices, or a couple people alone. So it's critical, if you find, as you think of aging and the natural aging process, to assign somebody that right to make sure you don't find yourself. Then the power of attorney document authorized somebody to handle all the legal and financial decisions. So my grandmother had Alzheimer's disease. And for years, my mother and her two brothers, which I wouldn't recommend, me individually would not recommend naming a multitude of people, especially three, because we can, like, that can get ugly. But nonetheless, is the power of attorney can give individuals the legal authority to make financial and legal decisions on your behalf if you're incapacitated. So my grandmother owned a meaningful farm, and they were able to continue to manage the farm, manage the farm's estate, the income, the taxes, and continue to operate her business on her behalf as she resided in a nursing home. In absence of that power of attorney, my family would have had to go through a long legal maneuverings in order to obtain that. And those power of attorney generally have some health qualifications that are there. The durable power of attorney is in response to HIPAA. So HIPAA was a piece of legislation was passed that protects it did a lot of things, but one of the things it did is protect our healthcare privacy. And so with the durable power of attorney for healthcare, it gives them the ability to make those healthcare decisions. So this is somebody who's incapacitated but not dying, right? And we want them to be able to make, you've been in an automobile accident, you want somebody to be able to elect to have a surgery or a procedure done, and it gives them the right to get that private information and to make those decisions on your behalf if you're unable to do so. So slightly different, that durable power of attorney of healthcare and the living will. We don't want somebody to use our living will when the durable power of attorney will do. Let's not pull that plug and we're going to be okay. So the good news is that the awareness in these healthcare initiatives and advanced directives have increased massively in the recent years. So in the last 10 years, we've seen an increase from only 30% of individuals having these sorts of documents to now upwards of 70%. With extended life expectancies and variety of treatment options, chance that someone else you're close to will benefit from these advanced directives are greater than ever. So, as we think about the population today in the United States, an aging population and the healthcare that's advancing at rates that are mind-boggling, the importance of these documents are even more on the forefront due to the reality that there's a higher probability that the majority of us will spend some period of our time between a state in which we can make decisions wholly and fit and full mental capacity to make decisions on our behalfs, and being in some period of window where we're not. So, and these are those documents, in my opinion, as I said, that regardless of your relationship status or child status, that are critical for every person to have. So let's talk about joint ownership, okay? We're going to talk about durable power of attorneys and living trust. So the joint ownership, to me, is one of the more creative or quality ways to move assets through and onto another person in a more simplistic way. So let's say, for instance, that my brother and I, we're of similar age and live in Indianapolis, we want to buy a house together. We want to make an investment together, right? For whatever reason. Well, a simple way to make sure that if I pass or he passes, that my portion or his portion, that my portion of that investment goes to him, not to my wife, not to my kids, right? Is to own that asset jointly, right? And it's typically called joint tenants' rights of survivorship is the way that is. There's joint tenancy in common and tenants by the entirety. And all those have a few different nuanceable elements to them. And not each one of them is appropriate. So we could talk about that if necessary on a one-on-one basis. But the value of ownership in a joint component is that it skips probate and it skips all those processes, and assets and ownership simply shifts to the surviving individual, that we provide a death certificate to the financial institution that's holding the assets, and those resources simply transfer into a single ownership for the surviving individual by law. And so joint ownership is one of those pieces that can simplify estate management for assets from that perspective. Again, if you have questions, I was just pausing there. I don't see any questions. If you have any questions, feel free to use that. So we've heard of power of attorneys. I would just want to dive into the durable element of the durable power of attorney, is that it is called durable because it includes specific language that allows to remain in effect or to take effect if you become mentally incompetent. You can go into effect immediately or when a specific trigger event occurs, such as you have a stroke or have an automobile accident, you're deemed to be incapacitated. And powers of attorney can be rescinded at any time and do not need to go through any sort of legal proceedings. And so the value of this is that in the time of crises, if we hit these triggering points, somebody automatically can step into the driver's seat. So, and then we have a living trust. Now, a living trust is great because each trust appoints a handful of folks, right? So you have a grantor, which is the person who puts the money in the trust. You have the beneficiary, which is the person who benefits from the trust. And then you have the trustee of the trust. And the trustee is the person in charge. And you can have multiple trustees, right? And so the value is let's say, for instance, that I want my mother to be able to have the authority to make financial decisions, both in life and death, over my resources. Then I could put resources into a living trust and name her co-trustee of said trust. The value then is that if I found myself in an incapacitated state, she already has the authority, and it's even more streamlined, if you will. Certainly a lot of trust would need to be had between you and that individual you've placed in that position. Let's talk about estate management for a little bit. So these are 2021 numbers. Great question. Thank you so much, Naomi. If I had the ability to send a gold star here. So let me read the questions. How does living trusts affect Medicaid eligibility? This is a great question. I appreciate that so much. So again, I can give you, Naomi, if you find yourself in a specific need, I can give you a name of I don't know where you're asking that question from, but if you're in Indiana, I've got a great attorney in Carmel I can connect you to, but let me speak in generality. And then if you need that contact, let me know. Or if anyone else on this Zoom needs that contact, let me know. Just drop your email in that and indicate what you need. So generally speaking, a living trust does not have any effect on Medicaid eligibility. And I mean that from a favorable or unfavorable way. So living trust still allow the individual to have access to the corpus or the value of the trust. And so from a Medicaid eligibility perspective, those assets would be included in a Medicaid spend down in general and be required to be consumed. Irrevocable trusts is really what we're looking for, which can be living trust. And so generally we call irrevocable trust. Often we don't call them irrevocable living trust. Technically that would be the right definition, but irrevocable trust then is what we need to utilize. And then there's a 5-year look back period on those. So yes, thank you, Naomi, for that follow-up. So Jeff Stinson at a Stinson law firm in Carmel is somebody we send a lot of our client families who find themselves in that situation for Medicaid. So thank you for that additional follow-up there. So any other questions on Medicaid, feel free to shoot them forward. I spent the first handful years of my career going around the state and teaching people on long-term care and Medicaid planning and asset preservation in that space. So certainly an area I have some strong familiarity with. So let's talk about gifting assets if we can. Gifting assets, so this is 2021 numbers. This number is now up to 17,000. But one of the ways we can manage the size of our estate is in the words of the Red Hot Chili Peppers, give it away, give it away, give it away now. So we can actually give up to $17,000 per person, per recipient, if you will, each and every year. And that number is indexed with inflation. And so say an individual is in a scenario where they look and they realize they're going to potentially start to creep up on the estate tax threshold of this 12.92 million. Now, one thing I want to pause and say and share with you is that in 2026, that number is going to revert back without an act of Congress, back to a much lower number of an inflation projected $6 to $7 million. So it's going to get cut in half in 2026. And so, 12 million sometimes may, or 13 million, almost 13 million can feel almost too huge to consider. But when we start thinking 6 to 7 million, that becomes, for many, a more realistic number that can occur. So we can give away $17,000 a year without triggering what's something called a gift tax. So, and my wife and I can do something called split gifting. Okay. So Lauren is her name. Lauren and I could give, I'm gonna make my this is getting recorded. I'm a little worried she might hold this to me, but Kara's my employee and dear friend. But so Lauren and I could, if we chose to, we're not going to, sorry, Kara, but we could give Kara $34,000 this year, and she would pay no income tax or estate tax or gift tax on that $34,000. And we can do that on forth. And let's say I could also give $34,000 to her husband, Steve, and $34,000 to her son as well. And so we add this all up, and in one family unit, I've now given pretty large amount of money, right? I don't know what you would call over six figures, but I'll call that a pretty big number. And so one of the ways that individuals manage the potential for estate taxes is if they just say somebody like my wife and I, who have 4 children, and let's say that all 4 of these individuals get married, and so now we're at 8 people, right? And here's some crazy math, right? Let's say that each one of them have 4 children, right? So now holy cow, right? That's a lot of, I hope not, that's 16. And then the original, that's holy smokes, that's 24 people that I could be giving, my wife and I could be giving it. Someone get out the calculator and let me know what that number is, if you will, put it in the chat. So, but you get the idea that for individuals, this is, it's very hard if you're gifting that level to grow your estate pretty quickly if you're giving that away. So, great. So I've got a great question here coming in. It's if you have a will with no children or next of kin and have all assets, home, land, car, and all items in it going to an individual you trust, is that better than a trust? So great question. So the question in general is if you have home, land, cars, and all those items in a will, you've already named all that and it's going to one individual, is that enough planning? I'd probably have to know a little bit more about that situation. If you're okay with that being in a public setting, state of Indiana, probate is generally a pretty simple process. And so a will in that case, it's a pretty simple situation that person has laid out. So in general, the more simple a situation, the more appropriate a will is. The more complex someone's financial situation is, where we have to take in special considerations for children, special needs, a right for privacy, assets in different states, these things, this is where we start to need the complexity of trusts in general. So, and yeah, I would say another question that came in, thank you for that, is it best for a single person to have a living will and a prepaid funeral, no assets other than a home and a car? Yeah, so if you own something, I think one of my favorite sayings is if you own 2 suits or you own 2 dresses, you can only be buried in one of them, right? And so one of the questions I think a lot of people say is, well, I don't have anything. Do I really need a will? Well, if you own a house, how do you direct where your house goes to, right? You have stuff inside the house. Who's going to get that? You may be fine. You can die intestate, right? That's fine. There is an orderly procedure, the distribution of your resources. It's just going to fall to Indiana or your state-specific laws. So you don't have to have one. But if you have desires to direct where your resources go outside of what the state has already put forth, then it's important. If that isn't the case in your scenario, then not so much. But I think one of the things that's often a misnomer is the complexities of a will. In the state of Indiana, you can get on a LegalZoom or a Law Depot or something of that nature and print a will. They'll walk you through the process. Have somebody who's not a beneficiary of your will witness it. Needs to be a disinterested party. Have a couple witnesses, and that counts. That's good enough. So you don't have to hire an attorney to do this. you can do something quite simple of that nature. Great questions. I hope I'm answering them well. It's always, some of these get a little bit more complex. So here's why we're going to want to have a trust, right? It's going to avoid probate, which again, depending upon where you are, that may or may not be a critical thing. And it is so not a matter of public record. A trust is a legal entity that can own property. Property structured trust can completely avoid probate, avoid those delays and expenses, accompany probate, and the trust is not a part of a record. So I'm giving you an example, speak specifically from my wife and I on for us. So Lord and I have a couple different trusts that we've established. One, we have trusts that are irrevocable living trusts. So these are trusts that we've set up during our lifetime for the benefit of our children. We've gifted money into these trusts that once our kids turn 25, I have the right to give it to them, or I can wait till they're 50. So I wanted to begin to build some money for our kids, some investments for our kids, but I didn't want to just put in their names and say it's theirs now. I wouldn't have the ability to have just a little bit of control over that. I don't know if you know anyone in college that made poor decisions, right? But I want to have a little bit of just restrings of control. Should my child or one of my children start making life choices that really didn't align with my wife and I, that God forbid they would find themselves in a state of addiction, or they found themselves in an abusive relationship, or they found themselves in a fill in the blank. I wanted to make sure I had the ability to protect them from the scenario that they're in at that stage and phase in life, right? So we established trust. In our will, we have something called a testamentary trust. And what that does is it takes all of our money and divides it in 4 buckets, and it puts somebody in charge of those 4 buckets for the benefit of our children until they reach ages in which my wife and I have deemed that we feel, hopefully, that they'll be responsible enough to get their share of the resources we've built. And so those are specific reasons, right, that we've set up these trusts, both living and while we're no longer living. So even after your death, a trust can provide some measure of control however assets are distributed to children and other beneficiaries. In addition, trusts are much more difficult to contest than a will. So I've set up some provisions inside these trusts of when my kids can get access to assets at certain ages that they can obtain, that they must obtain. And so it's going to be much harder for my youngest Charles to say, no, I should get the rest of dad's money at 22, right? Versus him having to wait till he's 40, right? Which is one of our provisions. So the ability to put some parameters of access to resources. So, and then there's it starts to bring forth a whole sort of complex set of tax and rules and regulations. So I'm going to pause on that because I think one of the most important things to understand is that there's a multitude of trusts. These are not vehicles to step into lightly, and that any idea around trust, we definitely want to involve a lawyer. I'm going to pause here before we go to the next slide for another. These questions have been great. Grab this next question. You're welcome. You're welcome. Just an expression of gratitude for the know that we don't have to go to an attorney for a will in the state of Indiana. So I'm not suggesting you shouldn't find an attorney, and we have those attorney resources we can introduce you to. I'm just saying there is other ways to do that that are certainly a lot less much more cost effective. So let's talk about how a trust works. And I think it's important to understand, when we think about a trust is just a document. It's a piece of paper. Well, actually, it's lots of pieces of paper. And so first, we need to think about the value of our estate. And we talk about that calculation. But one of the things that is often forgotten is that we're going to include, and I think most people think of this property, your home, your real estate, so other things other than your house, cash, bank accounts, investment, retirement plans, business interest. Most people think of that. But then there's this last one. You see, the life insurance that you own, that you're the owner of, counts in the estate tax calculation. So some people say, $6 million? Mighty, that's a lot of money. I said, that's right, that is. And there'll be somebody my age, and maybe they've been a good little saver, they're a high income earner. And because of that, they own a lot of life insurance to take care of a multitude of children like I have. All right. Well, what can happen is that somebody like me who has done a decent amount of, decent job saving, but then also needs a large amount of life insurance to take care of their family, could suddenly find themselves triggering estate taxes on their passing, especially if they're a single individual, so it's just them, and they can cross over that $12 million threshold. So, what can go into a trust? Personal property, home, real estate, cash, bank accounts, investments, real estate plans, business interest, really almost anything can go inside of a trust. The only thing that can't go inside of a trust well or easily is retirement plans. It's hard to get that inside of a trust. So the first thing we have to do is establish a trust and define the people that are going to be in each roles. And then the second step we have to do is we actually have to move money into the trust. And what's fascinating is a lot of people forget that last step. And so this would involve retitling assets in the name of this trust document, that the trust actually becomes the owner of the asset, as odd as that is. So this non-living entity can actually own these things. So, the questions we want to ask before we even think about this is, who do you want to inherit your assets? Whom do you want handling your financial affairs if you ever incapacitated? Whom would you want to make medical decisions for you if you become... if I say anything today, you're going to write down, because if you can answer these questions, if you meet with an attorney, it's going to save you a lot of money. If you're prepared to answer these things, because this is the stuff an attorney needs to know. All right. So who do you want to get your stuff? All right. Call that inheriting. Who do you want handling your financial affairs if you can't? Who do you want to make medical decisions for you if you can't? Do you want to provide for your spouse if you should die first? I would suggest that's a good move, but that's for you and them to decide. Do you have young children you want to provide for? Again, probably a good idea, but that's up to you, right? If your children are grown, do you want to distribute your estate equally, if not perfectly equally? So that's an important one. So my dad's oldest child was an individual who was an experienced addiction, and her addiction was crippling at best, and ultimately took her life. And so when my father did this planning, I don't mean to be so shocking with that information, but when my father did his own estate plan, he had to take that into consideration, right? So one of the things we often recommend to people is, don't just check the beneficiary box and move on. Please take into consideration your children, their unique needs, their unique preparedness. And loving somebody well doesn't mean necessarily leaving them an equal share of what you have. So, and then will you need to provide cash to help your heirs settle their estate, which is where that estate tax comes in. I've got 2 more questions. The answer to these is to go along. I love it. I love it. Thank you, everyone, for asking. I love this. So great question on the... So you have... I've got a question on, does Indiana have an estate tax? No. So you have typically, and it's interesting, typically when it's at the state level, it's called an inheritance tax, an odd thing. Indiana used to have one where it didn't matter where the person who deceased died. It was taxation levied on the recipient of the tax. So if you inherited assets from somebody who lived outside the state of Indiana, but you're a resident of Indiana, then that tax was leveled at the recipient level. Isn't that a funny nuance? Sorry, I promise. I'm married. Can you believe that? Geeky at that level, and I'm married. Nuts stuff. Anyways, moving right along. Can an HSA be put into a trust? I do not believe so. It's a great question. I'd have to double check on that one, but I do not believe so. Mainly because of its tax qualified benefits. Generally speaking, assets that are tax qualified are hard to put inside, or generally unable to be put inside of a trust. So that's a new question for me. But based upon precedents, I'd say no. I'd have to double check that one. Thank you for that question. It's good stuff. Love it. So let's talk about one specific thing. All right. So we're going to talk about a tactic here. And this is one of the ones that I think is kind of interesting. So life insurance can play a critical role in estate management, particularly when used in conjunction with a trust. So we'll have instances where individuals are well under the estate tax threshold and are projected to be well under the estate tax threshold long into the future. but they have loved ones they want to take care of, and we'll explain to them, congratulations, Mr. and Mrs. Saver, you've done an amazing job. You're 60 years old and you have $1.5 million in your IRA and you have 2 kids. And they'll say, yeah, can you believe it? And we don't even think we're going to touch much of that IRA because we have pensions, we have Social Security, and we're really frugal and we don't own a mortgage. So we're going to leave our kids $1.5 million. Kyle? I said, no, you're not. And they'll look at me like a little sad face. I'll say, why not? I said, well, what happens is that $1.5 million is going to be subjected to income and respected decedent tax. And you raise successful children that are top earners. And so all of that money is going to come out when you die at their ordinary income tax level. And it's really ugly. And so what some people will do is they'll own life insurance inside of a trust. And that life insurance can provide money to pay for estate taxes. It can be set up outside your state, and you can gift that life insurance policy to the trust. So the trust actually owns its life insurance contract. And so what makes this a powerful tool is this trust is a separate entity. And under the strategy, the person establishes the irrevocable trust, funds it. Trust then purchases life insurance on the policy that you set it up. So this trust owns a policy on you. When you die, the trust gets funded with the life insurance that's outside your taxable state. And it can be used to pay for things like income and respect of the decedent tax, or it can cover estate taxes if you find yourself in that scenario, or it could provide the liquidity for a successful transition of a business if necessary. So there's a lot of reasons that are specific, but the value here is this trust is a separate entity that does not get included in the estate tax calculation or subject to estate taxes or income in respect to the decedent tax at all. And so we can have a large vehicle over here to take care of the liquidity needs of someone's estate without subjecting that liquidity to the taxation that may have been applied depending on someone's financial situation. So keep in mind, lots of factors affect the cost of life insurance. This tactic is certainly not for everyone, including age and health. So, but just to help an understanding of a deeper planning element there. So I wanted to keep today pretty high level, right? You all have asked some really great questions. I wanted to focus more on the foundations and not get into deep specific planning elements. But I want to talk about here kind of in wrapping those pieces that we want to. So the first thing you need to figure out is what is the value of your estate, right? And don't forget your life insurance in that calculation, group, term, all those things, and add it all together, right? And if you find that in a scenario that today or in the future, that's going to be bumping up against the current 12 million or the future 6 million, then you've definitely have some urgent planning needs. In addition to that, though, are objectives, right? And I would argue that most of us fall under this category, right? So it's that list of the who, the why, and the what. So when I thought about my own estate planning, one of the things I have done as an advisor for over close to 20 years now, it's at 20 years, time flies. So one of the things that I thought about as I've served many families through the transition of a loss of a loved one, is I thought about what are those things that I wanted for the people I love if I'd leave this earth a little earlier than I hope. One of the things I wanted is simplicity, I wanted convenience, and I wanted stability, okay? So let me unpack those if I want, right? One of the things I wanted to make sure is I didn't overcomplicate things for them. I wanted to do the least amount of planning I needed to do in order to make sure that their lives continued on as if I was here from a financial perspective, right? I wanted everything to be convenient, right? So where I could, I wanted to use things like joint ownership and name beneficiaries. And so we didn't need to get into trust and those things. And then stability. I wanted to make sure that there was enough cash through life insurance and other planning tools that the lifestyle that the loved ones that I have a 10, an 8, a 4, and a 1-year-old. Do that again, 10, 8, 4, and 1. In case any of you all thought you were busy, come to my house for a minute. It's a great time. It's a great time. It looks like Toys R Us exploded. In fact, I don't think Toys R Us exists anymore, but I think you get the point. So nonetheless, Those are my goals. Leaving a legacy financially to my children was very, very important to me. It may not be to each and every one of you, right? We've served individuals who have children who are experiencing and living with special needs. One of my very best friends has cerebral palsy. The planning for Kyle, his name is Kyle as well, is different for others than it may be for my children who are not experiencing cerebral palsy. So we need to take each situation into consideration. And I'm honored to be connected to a network of attorneys here that can serve folks in nearly any situation they're in. So principles of estate management are important for reasons, but I want to kind of give some examples of things we've heard over the years. Is one of the things we've heard from our clients or grandchildren is, what is the best way to give assets to our children and grandchildren? We have a blended family, right? So I'm a product of a blended family. My father had 2 daughters before he married my mother. And so this can complicate things. And a question can be asked is, what sort of trust is appropriate? My mother lives on a farm that was bought by my father's dad, so my paternal grandfather. It's complex. That's not unusual either, right? Retired couple wants to know, is it living trust or is it trouble, right? Expenses to set up. What's the best way for us to take title of our assets? It's a common question, right? Often we hear all these legal mumbo jumbo, right? We say, well, is that for me? It's not complex, it's not expensive, and it can be. And none of this that I've shared with you today. Business owners, how should I protect my business interest in the event of my passing? It's a critical one. If you own a business, you or a loved one owns a business, this becomes a critical piece. Business ownership can be complex when it comes to passing business ownership. And there's some really special and advanced planning one can do to shield that from taxation. That gets into fun stuff. So, and I think for business owners, they have to think about succession, who is going to be managing the business on an ongoing basis, things of that nature, right? One of the ones that we get a lot is, I got online, did some research. Our critical healthcare documents, I downloaded legal blinding, and how can I make sure I avoid probate and estate taxes, right? So there's a variety of questions we get. I thank you for the ones you've been asking to me today. So that is my contact information, okay? And there's a number of available tools for effective estate management. But first, you need a good estate management team in place. And so that's certainly where we come into play. We help people in the space. We partner with attorneys and CPAs to help individuals understand what their exposure is when appropriate. Certainly, I'm going to pause here to make sure I've got any other questions. I think we grabbed all of them. I love it. I love it. I love it. For those who ask questions, thank you. Your gold stars are in the mail. I thank you for spending some time with us on this lunchtime educational series on estate matters. So if there's no other questions, I don't see any of them coming in. Please take a moment after this and consider whether you feel the planning you've done is enough to make sure what you own goes to those you love properly. If you have any questions, certainly, I knew if I chatted long enough, we get one more. The final question. I feel like I should have a drum roll. Oh, you're welcome, Tara. Thank you for your kind words. I'm glad you found it helpful. So without any further ado, I'll send you all off back to your day. Thank you so much for your time being part of this with us. And certainly feel free to reach out should you have any additional questions. And we look forward to providing you additional educational information in the future. Be well.